Hi everyone, I welcome you back to our channel. This is Legal Mindset at the bar, and today we are in for Contract Law 1. Uh, this is a very interesting topic, a keen topic, though it is technical. That means you should be attentive and keen. The topic of privity of contract, the doctrine of privity. I urge you to be very attentive. Watch this video bit by bit. You can also pause to follow and understand all the principles therein. I dedicate this video to all of you students from different universities: Uganda Christian University, Makerere University, IU, Mkumba University, Kabale University, as you are going in for your exams. This doctrine of privity is an examinable area. So, by the end of this session, you should be able to know what privity means. Where do we drive privity? What are the fundamental cases, the locus classicus cases in privity of contract? As any general rule, what are the exceptions to the general rule under the doctrine of privity? Let us now dive into it, but before, touch that subscription bar, like, share, and comment where you feel like you're not satisfied. By subscribing, turn on the notifications, because in this examination period, we are going to be releasing a number of videos how to answer, such that they are brought to your attention. Hang on until the end of this video, where I shall show you a number of exceptions. So, the doctrine of privity. The doctrine of privity of contract states that only a party to the contract can enforce its terms or is bound by the terms of that contract. It means outsiders or strangers to a contract cannot impose obligations or claim benefits, or even if that contract is made for their benefit, they cannot enforce the same. If you are not party to the contract, you cannot enforce that contract, as a general rule in the doctrine of privity of contract. And if you go to our previous topic on our channel, consideration, we discussed among the rules of consideration, and we said that consideration must move from the promisee. It means that if you did not provide a consideration for the object or for a contract, you cannot enforce it. You are not party to that contract. Because if the consideration did not move from the promisee to the promiser, only the promiser and the promisee can enforce that contract. I urge you to look at section 1, which shall define for you who is a promisee, who is a promiser, what is a promise. And the promiser is the person who makes the terms of the offer, and the promisee is the one who accepts them. So the promiser and the promisee are the only parties to the contract here on the doctrine of privity, and they are the only parties who can enforce that contract. This rule that privity of contract, a party to the contract is only the person to enforce that contract, is based on the interest theory. The interest theory means that only those directly interested in a contract can be legally entitled to it, can be legally entitled to protect their rights under the contract. So, let us understand that privity of contract means that only a party to the contract can enforce that contract. Now, I'm going to take you through two cases, but these cases are going to elaborate and they are going to make you understand what really privity means. First, I shall take you through the case of Fido versus Atkinson. Though, I urge you to take the case of Dunlop and Tire Company Limited versus Selfridge as the first case. Let me explain to you the case of Fido versus Atkinson, because for it it is somehow friendly. Students have tended to understand it very well. And in Tudor versus Atkinson, a couple were getting married. The father of the bride entered an agreement with the father of the groom, and they agreed that they would pay the couple a sum of money upon their marriage. But both parents died before making their promise good. The groom now made a claim against the executors of the will that she should be paid, the money the father had promised. Court held that the groom was not party to that contract. They provided no consideration for the contract. They could not participate in enforcing it. This thing is very simple. If you are not party to a contract, you cannot enforce it. That's what court held. Court held that where the fathers were agreeing to pay, the groom was not party to that contract. It was none of her business. She could not enforce it. And she could also not be sued or sue under that contract. Let us now look at the general case in privity of contract. The case of Dunlop Tire Company Limited versus Selfridge and Company Limited. It is a case of 1915. SC page 847. And in that case, Dunlop and Tire Company Limited. Colleagues, pay attention. If you have been doing anything, catch a pen and a paper and write down this case under privity. Dunlop and Tire Company Limited versus Selfridge and Company Limited. The facts are like Dunlop and Tire Company Limited sold tires to Dew and Company. Quote me well. They sold tires to Dew and Company and agreed that Dew and Company would not sell the tires below a fixed retail price. Their agreement was like Dew and Company should not exceed a certain amount of money while selling those tires. So Dew and Company further also sold the tires to Selfridge and told Selfridge that do not sell these tires below this amount. But however, after Selfridge, a good businessman, getting those tires, for him he sold the tires below that price they stated. Now, Dunlop, a party who contracted with Dew and Company, now came in to sue Selfridge for breach of contract, and he sued for damages. The House of Lords held that Dunlop could not sue Selfridge. Why? Because there was no consideration that moved from Dunlop to Selfridge. In other words, Dunlop was not party to the contract. Selfridge contracted with Dew and Company. So the contract was none of Dunlop's business. He could not enforce it. That is the doctrine of privity. A party who is not part of the contract cannot enforce it. Lord Holden stated that only a person who is party to the contract can sue on it. Now, let us continue. We are going to be slow but sure because I want you to excel. I want you to score high in your exams. We have now looked at the general rule that a party who is not part of the contract cannot enforce it. We have looked at the case of Tudor versus Atkinson, Selfridge versus Dunlop. Let us now look at the exceptions to the doctrine of privity. What are these exceptions? What are the instances where a party who is not part of the contract can now come in and sue? We are going to look at a number of them. We shall look at agents, we shall look at insurance contracts, we shall look at assignment of contract, negligence, statutory exceptions, and a number of them. To begin with, agents. Agents is one of the exceptions to the doctrine of privity. An agent is a person employed by someone to do something on their behalf. where an agent gets into a contract on behalf of the principal. Therefore, the principal can sue or be sued if they are, even if they are not party to the contract. Now, look at section 118 of the Contract Act, Cap 284, which defines an agent to mean a person employed by the principal to do any act for the principal or to represent the principal in dealing with the third party. Look at these words very well. In agents, uh, an agent is a person employed by the principal to represent them in their contracts. The principal is that person who employs the agent. You can also look at the sub-agent, that one employed by the agent. All the repercussions of the agent and the sub-agent can be enforceable by the principal. Look at these things of MTN, Airtel. Those guys who come uh, with lines, they are selling them on behalf of MTN. If they do something, if they defraud you, you can sue MTN direct because this party are working under their name. They are agents. Now, if you go on and look at section 126, subsection 1 of the Contract Act, it provides that when an agent is properly appointed, when an agent is properly appointed by the principal, that principal is bound and responsible by the acts of the agent. It means it is an exception to the doctrine of privity. Now, let us look at insurance contracts as another exception to the general rule that a party who is not part of the contract cannot enforce it. In insurance contracts and a third party insurance, a party who is not part of the contract can enforce it. Take an example like the motorcycle third party. If you get an accident on a border, you can enforce it. You enforce, you go to the insurance company, they cover for you because that motor third party insurance is intended to benefit you, the third party, because the parties to the contract are the insurance company and the owner of the motorcycle. But you, the third party who is sitting on the motorcycle, you can now enforce the contract because it is made for your benefit. Let us now look at another exception, assignment of contracts. Here, if the benefit of contract is assigned to a third party, that third party to whom the benefit of contract is assigned to can enforce that contract. Take an example like, I demand you some money, you the viewer, I demand you 200k, and now I'm leaving Kansanga for the United States, and I call my son, I tell him that that guy will pay you 200 pounds. I demand him. We write it down. It means I have assigned that contract to my child or to my friend. They can enforce that contract. Now, we are going to look at negligence. What is negligence? You should be very keen on the law of negligence because it was changed by the case of Donju versus Stevenson. In negligence, a person who is not party to the contract can enforce it. I'm going to give you an interesting case of Donju versus Stevenson. In Donju versus Stevenson, Mrs. May Donju was not party to the contract. She did not contract. But while she did not contract with Stevenson, they went to a certain cafe. They ordered for a bottle of ginger beer, but a friend bought for her the ginger beer. Now, while taking the ginger beer, she found out that there were remains of a decomposed snail. Remember, she's not party to the contract. What she did, she sued the manufacturer. And the issue was the person is not party to the contract and they are trying to enforce it. Now, Lord Atkin came in and he stated, he brought in the neighbor principle, stated that you should treat your neighbor as you treat yourself. The law of negligence, he stated that you should not show that you are a contracting party. Showing that you're a contracting party is irrelevant in negligence. As long as the other party acts negligently, you can sue them under the law of negligence, as Lord Atkin stated in the case of Dongue versus Stevenson. Let us now look at statutory exceptions. And under statutory exceptions, I urge you to be very clean and clear because they are somehow confusing, but that's what we came to solve for you, our dear viewers. What are statutory exceptions? This is where a statute comes in to say that a party who is not party to the contract can come and sue under it. I urge you to look at section 65, subsection 1, paragraph A of the Contract Act, cap 284, which states that a person who is not party to the contract may in his or her own right enforce the terms of that contract, where the contract expressly provides that he or she may do so. The bottom line in that section is that if we write down that a third party will come in and enforce our contract, that third party shall be bound to sue under our contract. You can look at subsection 2 under section 65 of the Contract Act, which says that where the contract confers a benefit to that person. Let us now continue and look at another exception, that is the law of trusts. The law of trusts is also technical. What is a trust? A trust is a legal arrangement in which a settler transfers property to another person, the trustee, to hold and manage that property to benefit a third party called the beneficiary. Now, who is a settler? Who is a trustee? Who is the beneficiary? I urge you to include all of these words in your essays to impress the examiner, to score high. And if you want to see us, if you want to see our next videos, subscribe, turn on the notifications. A settler is a person who creates the trust and transfers property into it. A trustee is the person who holds and manages the property according to the terms of the trust. Now, the beneficiary is the person who will benefit from that trust. And the beneficiary has a right to enforce that trust. Take an example like your father went abroad, but before going abroad, he left certain property to his friend and told him that when my son gets 25 years old, transfer that house, transfer that apartment to him. When that period reaches and the trustee refuses to do the same, you can enforce that agreement. Let us now look at our last exception, the bills of exchange. And under bills of exchange, a bill of exchange is a written unconditional order by one person. That person is called the drawer, directing another person, the drawee, to pay a certain sum of money to the third party. And that third party is called the payee at a specified time. The drawer is the person who creates the bill and makes its payment. The drawee is the person who is directed to pay the money, and the payee is the person who gets the money. And in bills of exchange, the payee has a right to enforce the terms of the contract. Thank you very much for watching Legal Mindset at the bar. Hit that subscription button below the video. Share with your colleagues. Keep the comments coming. Turn on the notifications because we are in a crucial period of exams. By turning on the notifications, all other videos will be brought to your attention. We are going to release a number of videos. We want our viewers to excel with the best grades. Thank you very much.